Good morning, everyone. I'm Kadambari from Asthana. Uh, our next panel is on right-based implications of the transfer system. To moderate this segment, I would like to invite Ms. Geetanjali Goel, Delhi Judiciary. She's an officer on Special Duty Rules and Litigation, High Court of Delhi. Ms. Goel has a BA Honours in Political Science from Lady Shri Ram College, a Bachelor's in Law and a Master's in Law from the Faculty of Law, University of Delhi. She has over 22 years of distinguished experience in the judicial services. After practicing law primarily in the Supreme Court, High Court, and Central Administrative Tribunal, she joined the coveted Delhi Judicial Service in 2003 and was promoted to Delhi Higher Judiciary Services in 2014. Over the years, she has presided over diverse jurisdictions, including civil court, cases of metropolitan magistrates, Mahila courts, and the Juvenile Justice Board as well. Promoted to the Delhi Higher Judicial Service in 2014, her judicial roles included assignments like the Motor Accident Claims Tribunal, Special Fast Track Court for Rape Matters, and Special Judge in CBI cases involving members of Parliament and members of legislative assemblies. She has also been the Director of the National Legal Services Authority and Special Secretary of the Delhi State Legal Services Authority. Currently, she is the Officer on Special Duty, Rules and Litigation at the High Court of Delhi. She has written several articles and contributed to the training modules prepared by the National Legal Services Authorities, given lectures on diverse topics regarding women's rights, child welfare law, disability law, and working of the criminal system in the country. She was member at the committee that drafted the Juvenile Justice Care and Protection of Children Model Rules 2016. I would like to invite ma'am to introduce the panelists. Thank you.
Good morning. So we've had very insightful and meaningful discussions yesterday. So I don't know whether there's much more to talk about, but I think several new perspectives will come in this session also. So this session, we are essentially talking about rights-based implications of the transfer system. I find this topic very interesting because the whole focus of this entire two-day discussion is on the rights implication of transfers. But when we look at the whole topic, the preliminary assessment and the way it has been drafted, so in fact, when we read the provision for the first time, the thought which came to my mind is what was reflected by Bharti also yesterday, that when you're talking about, that when we're trying to find out the capacity of the child to have committed the offense, the circumstances and the consequences, then somewhere we are doing away with the rights of the child because we are starting with the basic presumption that the child has committed the offense. And that goes against the presumption of innocence, which we keep talking about, and which is also part of the fundamental principles. Now, having said that, I would also say that since we are practitioners of law, we are sitting like as judiciary also. So once the law is there, the judges have to follow the law. So Bharti had raised this very pertinent question that can the judges or the principal magistrates or even the JJBs refuse to do preliminary assessments because we don't agree with it or it is in violation of the rights of the children. Now, if you look at the law as it has developed, so there have been matters on preliminary assessment which have gone up to the superior courts, to the Honorable Supreme Court also, but this preliminary assessment has not been declared unconstitutional or ultra virus by any of the superior courts. So in that context, we have bold judges, but then still it is very difficult for the JJBs to say that we will not conduct preliminary assessments simply because in their opinion it violates the principles or fundamental principles or the rights of the children. Having said that, while we still need to reflect on how the system of transfer affects the rights of the children, we also need to have a dialogue on how we can attune this system of preliminary assessment to protect the rights of the children and to ensure that the fundamental principles are followed. So I think one part of the focus also needs to be how we can make the system more germane to the whole objective of the Juvenile Justice Act and try to ensure that now we have to do a preliminary assessment, but at least we can ensure that the rights of the children are protected. So with that background, I may also just add one thing following from Maruk. So Maruk has very elaborately discussed everything, I think, which the concerns which are there before us. So falling from her, when this provision came in, I remember in Delhi observation homes, there was suddenly a lot of distress amongst the children, because obviously they were hearing from all over that, tomorrow they are going to be sent to the adult courts, they'll be tried as children, they can get any sort of punishment. So obviously, other than the trauma which the child himself or herself faces, then they allegedly commit an offense. The whole trauma of going through the JJB process and then going through the children's court process. So it also affects the children themselves. So that is something which we need to keep in mind. So we have a very distinguished panel here to have discussion on this topic. First and foremost, we have Anant Asthana. Anant, do you see us? Anant?
Yes, ma'am, I see you. I see everybody else also.
So Anant does not need any introduction. I think all of us know him. And but anyway, so like he's been a child rights activist since I have known, and I think even before I came to JJB. So he has a long history of that. Uh, He's a child justice and criminal lawyer, works in and outside courts trying to bend the arc of law and justice in favor of children, the powerless, and the vulnerable. So he has done a number of litigations in the Delhi High Court where he has tried to further the rights of children or even challenged various provisions. So maybe one day Anand will challenge Section 15 for us, if that is possible. So anyway, Anand, so I did say that I'm not going to put any questions to any of the speakers, but since this issue came up during one of the sessions yesterday, while you can speak whatever you wish to say, I would just like to put one question to you. So in your experience in Delhi JJPs as well as in other places, have you come across cases where lawyers have not argued on PA at all? I mean, the lawyers have just said that this is for the board to decide and we will not argue it, or that the lawyers have raised this question that they are not being provided documents on the basis of which they can argue PA. Because provision of documents also forms the essence of principles of natural justice and the right to be able to argue well for the child. So over to you. Each speaker will have about 5 minutes, and then we can go back to the speakers later on. Okay? So Anant.
So I start right away, ma'am.
Sorry?
I start right away.
Yes.
Okay. So I'm grateful that this opportunity has been given to me, and I'm also grateful to Geetanjali ma'am for asking this question, because I think Delhi owes a lot of bad practices to the country in terms of PA. When the lawyers started demanding that the documents be supplied, it was JJBs of Delhi who responded in a way they should not have, and they created a sealed document, sealed package, and they put the PA report inside that packet, saying, it's sealed from any kind of inspection, and this was done despite the appellate courts deprecating this practice. It was done after a case where a party, a child in conflict with law, wanted access to the documents because those documents were being read against the child, and the lawyer wanted those documents. And it was said, no, you can't have a document because it's between me, board and the expert. It's not a document which you should have. And then the matter went into appeal. And the appeal acknowledged the right of the CCL to have access to the document and to have a cross-examination of the expert. But the effect of that appeal was that the report, which was earlier available on the judicial file as an open document, went into a packet, sealed packet, right? So that even during inspection, nobody can get it. So, and I think it's a bad practice. I don't know whether constitutional courts have even looked at it so far, but it does create a lot of problem. PA report, I have been constantly reminding everybody that the creation of a report called PA report in itself defeats the purpose of the act. The act creates a judicial process called preliminary assessment, but what has happened is that it has been repackaged by the lower judiciary, particularly juvenile boards, into uh, a kind of a package. For example, there is an order, do PA, right? most of the boards don't even take the trouble to point out on which aspect the opinion is required, right? So the whole preliminary assessment is seen as one process and is delegated to some expert. And I have seen in some states, even the permanent committees have been set up of these experts, right? Completely depriving juvenile board from having any access to any other kind of expert. When a state appoints a committee that these are the people who are going to give you mandatory reports, it creates a huge space for violating rights of the child who is going to face the consequences of the PA. So yes, lawyers have been asking, and there has been a conscious pushback uh, to have a part, and that's why the Barun Chandra came. Barun Chandra judgment was uh, was precisely based on reasonable opportunity, because these reasonable opportunities were being systematically denied to the children in conflict with law. And I'm so glad that the Supreme Court acknowledged it and tried to open it through some kind of guideline. I will just go further and flag some issues which I want to place for your consideration. Is there is a huge body of academic, legal, administrative, juridical, both kind of documented and undocumented work which has happened on this specific aspect in past 10 years. There are experiences which have resulted into various kind of initiatives being taken administratively, also judicially, uh, but the response is not consistent and is not informed uh, by the rights of the CCLs. For example, the rule which Geetanjali ma'am had asked during Maharukh session, the rule 13, which conflated right to appeal with section 19, that rule was held unconstitutional by the Patna High Court in Lallu Singh, right? Now that finding has been unsettled by the Supreme Court in CCL through Mother versus State of Karnataka, because Honorable Supreme Court has said that the children court and session court mean same, right? I mean, that's not the correct interpretation in my understanding. The act was very consciously creating the distinction between session court and children court so as to protect the right of the appeal of the CCL. Now that right to appeal has been merged into section 19 relief. Second aspect which I want to bring is that when a child litigates for a long time to prove that the process of the preliminary assessment was wrong, what is being done consistently by the superior court is that sending the case back for curing the defect. Now, I have been saying that the child loses anyway. Child litigated for 2 years to prove that the PA was wrong. Instead of just saying that the PA was wrong and giving the child the relief, why would somebody send the case back and give one more opportunity to JJB to now do it correctly? So earlier, the principal magistrate alone wrote the PA order, child fought against it, and the case goes back. And this time, the same thing is written, but the signature of social worker is also added. Now, how does that?
Minutes up. So quickly wind up, please.
Yes. Right. So that practice has taken root, ma'am, and I think it's important that I draw attention of this house towards that. Uh, third point which I want to make is that Maruk has briefly touched about it. The children who come into contact with the juvenile justice system at a belated stage, at the age of 18, 19, 20, 21, because they are initially treated as adult, the whole regime on PA is not aligned, right? It doesn't work in their cases, and the cases get so complicated that that there is no way out for them. In conclusion, what I will say is that the whole practice around PA has taken a very alarming um manner. And why I'm saying alarming is that, as an adult accused, at least there is some accountability on police, on judges, on jail administration towards an adult accused. In terms of children, there is an accountability of child protection system, but the children who got trapped into this, who are neither children nor adult, nobody knows whose children they are. So they are literally orphan in a system where everybody is there and nobody wants to take responsibility for them, right? So I call upon
I'll have
everybody's attention to that, and I conclude with this.
Okay, so we'll come back to you later. Okay, so next we have Mr. Sreejith A, who is an advocate and currently serving as a member of the JJB, Kasargode district in Kerala. So I must say that JJB is the main player or maybe the villain in the whole PA system. So you have a very important role to play. Uh, Sreejith is previously served as a CWC member from 2022 to 2025. And prior to that, he was a legal cum probation officer at DCPU Kasargode from 2016 to 2021. And he brings a rich, in-depth experience of having worked closely with children in conflict with law. So he has donned several hats. So I think you are the best person to talk on this subject. But I would also like you to reflect specifically on when you're sitting in the JJB, do you go out of your way in any manner to protect the rights of children or look at fundamental principles in relation to PA?
Good morning to all. Here I will stop my word in a few words. I am not going to say elaborately. The thing is, we all the people gathered here are the stakeholders of the JJ system. We are here to stand for the children and for their right, child rights. Today topic is right-based implication of PA system, the transfer system. Basically, the right and transfer will not go together. If we are transferring the child to children's court, definitely there is a child rights violation. The question whether we are with the child rights violation by transferring the child to the children's court, whether we have to do that is our question. My answer is no. We need not transfer the child by curtailing the rights. Is not fair. It's my opinion. Then there is a issue. Still, there is a act. The act and rule says that we have to transfer the child to children's court. But there are several provisions in the law. We are dealing with the JJ Act. You are all know about the JJ Act. The section 3 is there. Section 3 is the principles. I just equivalent the principle of section 3 as to the preamble of Indian Constitution. What importance to the preamble to the Indian Constitution have, the same importance is to the section 3 having, I say. Section 3, I am not going to all the presumption principles. Everybody know that principle. We have to follow the principle while taking any decision with regard to child. Madam told whether we go beyond the role and all. If we take any decision, we have to follow the principles. Basically, the principles is against the transfer system. The principles of child is against the transfer system. Then if there any conflict arises, in the case of Constitution, if there any provision of the Constitution is having any conflict with the preamble or fundamental rights, the fundamental rights or the preamble will prevail, right? I think so. There are some eminent lawyers are also here. I think when the conflict between the preamble and the fundamental rights and the other parts of the constitution arise, the preamble or the fundamental rights will stand. Likewise, we can take it in the same manner. Any provision of the JJ Act is in conflict with the Section 3. I think I say the Section 3 will prevail because that is for the children. That section is alone for the children. If we take any decision, we have to follow, we have to satisfy the presumption principles contemplated under Section 3. That's my main point. And one more thing, whether we need to use that section, cannot use that section is the second question. It is mandated that we have to come at section 15 says that shall conduct the preliminary inquiry. Okay, we can conduct the preliminary inquiry because we know the child better. While conducting the preliminary inquiry, the JJ board will know the child better. Then the second question, whether we have to transfer the child to children's court. That may be transfer. No, shall is not there. May transfer the child. My answer, being that transfer is against the interest of the child, that itself violate the child rights. We need not transfer the child to children's court. We all the lawyers know there are several laws that and provisions of law. All the laws and all the provisions of the law are not being practiced or implemented. When we are again remembering the constitution, the article 356 regarding the emergency, while that is in the constitution, the discussion, the Ambedkar says only one point. The Ambedkar says that keep it there. The provision of emergency is there. It is not to use. The same thing I am say that the transfer system is not to use. Let it be there.
Thank you for your inputs. So now we have Swagata, one of the brains and the reasons why we all are here. So Swagata had raised several issues even during the inaugural address. So I hope that she'll continue with that and delve deeper into those issues. So just to introduce her, though she doesn't need the introduction, she's the Director Research and Co-Director of Restorative Practices at Enfold Proactive Health Trust. She's a legal researcher, trainer, teacher, and restorative practices practitioner with 20 years of experience. She has led several research studies on the implementation of the POCSO and JJ Act and has contributed towards the drafting of juvenile justice rules in Karnataka and Madhya Pradesh. Over to you.
Thank you, ma'am. I'm going to start by saying that I would start by disagreeing with you in terms of, how can we do this better? My point would be that this should not be about how can we do Section 15 better, Section 19 better, Section 20 better. But the question to ask is, do they even meet the standards of procedural fairness and equality under the Indian Constitution? So I'm going to anchor this in the context of 4 rights. Let's start with the presumption of innocence, the first principle that is there in the JJ Act. And we've done interviews with almost over 120 JJBs across 5 states. And what has emerged very clearly for them is that the exercise of preliminary assessment is for them to assess if the child has done the offense accidentally, was it a mistake, or was there provocation, or was there premeditation. So at the very first instance, you are moving with the assumption that the child has actually committed the offense, and now you are going to find out whether the child was an accessory or the child was the master planner of this entire exercise. And who comes to support the JJB in terms of arriving at this conclusion are the wonderful mental health experts, many of whom are in this room and outside, who are preparing these reports, including information that is incriminating in that report that the JJB is then relying on to transfer the child. Or even the probation officer's report. So when the circumstances, and yesterday there was a lot of conversation on circumstances of the child, but most reports tell us the circumstances, what led to the crime. What happened, who provoked the child, who called the child to place A, place B, and then what happened, and then how was that offense committed. So there is a lot of incriminating information in these reports that then the JJBs rely on to say that, okay, the child has very clearly committed this offense and therefore we have to transfer. We've spoken a lot about SIRs being bare, about reports being bare. JJB orders are also very bare. They do not tell us exactly on what basis has the JJB decided this child has mental, physical capacity, what is the understanding of consequences, what are the circumstances. It is also a one-line order, many a times, saying that, this is what the report is saying, and therefore the child has capacity and can be transferred. So where is the privilege against self-incrimination, which the Constitution recognizes a fundamental right, when no one is telling this child that this is the consequence of you sharing information with us? And we've spoken to a multitude of stakeholders, including mental health practitioners, JJB social work members, who see their duty as being making the child comfortable. And what they tell the child is, we are here to help you. So please open up and please tell us so that we can help you get to a school. Or, share information with us so that you can be released on bail, you can go back to your family. No one is telling them that the information you share with us can potentially, lead you to be transferred, potentially lead you to jail. That's not information that is shared. I think yesterday a point was made that, we want to hear the child unmanipulated. What is the first version the child is telling us? I think somewhere we've forgotten that the consequences of, having the child give you that information is going to be used against that child. The child doesn't know that. The principal problem that I have with the provision is when we look at it on the touchstone of equality, the right to equality, which is there in Article 14 of the Indian Constitution. Now, age-based distinctions are by nature not discriminatory. That's why we have the JJ Act. That's why we have, the child labor saying above 14, you can work in non-hazardous work. So I'm not saying that there cannot be age-based distinctions. The test is, does this particular age-based distinction meet the test of reasonable classification? What is the intelligible difference between a 16 to 18-year-old and those below 16? We have brought in age and offense as being the criteria for creating this distinction, and this distinction leads to disadvantage. So you are a 16-year-old accused of a heinous offense, you are transferred, another 16-year-old is retained. World of difference in terms of what your life is going to pan out. If you are found guilty, your records are going to be kept. The detention is the only option available to a children's court when it finds a child guilty, as opposed to a JJB where there are a lot of non-custodial options that are available. And jail, the possibility of being sent to jail exists for a 16-year-old who's tried as an adult and convicted, which does not exist for a 16-year-old who's retained, does not exist for a person below 18 who's accused of a non-heinous offense, or for a child below 16 accused of a heinous offense. So there are multiple levels of discrimination that we are seeing that a 16 to 18-year-old is subjected to. The second aspect is substantive equality. When we speak about equality, we're also looking at, in the context of children, the best interest of the child has to be considered if we are truly to advance what their rights are. And can anyone, look at the articulation of the principle of best interest in the JJ Act, which says all decisions regarding the child shall be based on the primary consideration that they are in the best interest of the child and to help the child to develop full potential. So I don't know how can we justify even the possibility of sending a child to a jail, even if that child is 21, as being in the best interest. So to conclude, I would say that if the JJ Act is our compass for children in conflict with the law, it is certainly not pointing to the north. And that's the question, we have to contend with.
Thank you. Now we have Dr. Eesha Sharma. So as we know, a lot hinges on the report of mental health experts when we are doing a PA. And so her inputs would be very, very valuable for this session. So Dr. Eesha Sharma is Associate Professor of Child and Adolescent Psychiatry at NIMHANS. She did her MBBS at KGMU Lucknow and then MD Psychiatry at NIMHANS. She had a keen clinical, academic and research interest in adverse childhood experiences. As a child mental health professional, she frequently assists children in need of care and protection and those in conflict with law with a focus on the best interest of the child. So, Dr. Eesha.
Thank you. It is a tremendous experience to have been in this gathering since yesterday. Thank you, Swagata, for having me in this. So, what I want to say is looking at the rights violation from a developmental and mental health perspective. Now, to me, the understanding of the Juvenile Justice Care and Protection Act, so at its core, is the idea of care and protection. So when I, try to understand what this law is for and, how we are party to it, what I understand is that it is meant to safeguard the most crucial and vulnerable phase of human life, which is childhood. This intent is very important because what is at stake is not merely legal compliance, but the protection of life and development itself. So the discussion, especially in the last session yesterday, when I think it illustrated in a very clear and nuanced manner about how systemic shortfalls impinge on children's rights, and Swagata also alluded to some of them in her talk. So the child-friendly procedures are unclear, there are prolonged, unpredictable timelines, all of which violate child rights, especially when the outcomes are not consonant with what seems to be developmental justice, right? What seems to be, in the best interest to help the child achieve its best potential. So the question that I want to pose is, does the juvenile system truly understand childhood? Does the system, is it capable of operating in a manner that actively upholds childhood and the requirement of childhood? Right? So I think that is a question that comes to my mind. Yesterday, Shekhar sir gave this example, which I've heard him speak about on so many occasions, about this boy who was slapped by his teacher and then he dropped out of school, and then there was a trajectory towards offending. To me, this story has always captured the dilemma that we're in its entirety. See, children and adolescents have emerging capacities. What are these emerging capacities? The capacity for impulse control, for perspective taking, and these are all still under construction, okay? They have not received the kind of maturity that maybe people in this room experience. So when we look at children who come into conflict with the law, I wish to say that the world is the problem. It becomes a problem when immature abilities are pushed, pulled, and twisted into coping with threat, when there is inadequate supervision, and there is a profound absence of engagement. Are our children conducively engaged? Are our children attending schools, living in families that really, are helping them achieve their best potential? In mental health, we often say that, see, children are not the typical demographic for mental illnesses, right? Mental illnesses are not, the peak of mental illnesses is not childhood. So if a child is getting diagnosed with a psychiatric disorder, the baseline is that there must be something deeply wrong with this child's ecology. I would like to extend that logic to children in conflict with the law as well. And maybe, I should ask the audience that, are children the typical demographic for serious offending? I would like to believe the answer is no. That's not the demographic where offenses peak. So if a child is coming into conflict with the law, there has to be something deeply wrong with the ecology that the child is coming from. So I don't think the occurrence of severe psychiatric disturbance and the occurrence of, criminal offending, so there is a commonality in terms of how we can understand them. Yes. So, okay, let me come to the part. So, see, most children, when we do the preliminary, we participate in the preliminary assessment. When the children comes to us, what is it that we're looking at? And Shekhar sir's work, I think, has laid it out with immense clarity in terms of, the approach that we can all keep for it. See, on the one hand, you have tests of ability. If you read any standard textbook of psychiatry, clinical psychology, it states it amply clearly that tests of ability have to be interpreted. Tests of ability have to be interpreted in the context that you are seeing a child in, right? A child's performance on a test of ability is affected by multitude factors, some of them operating in the here and now, some of them longitudinally affecting how this child processes information. So tests of ability is one part of the assessment, that is it. And to me, that's not even the most important part. After that comes what, see, the UNCRC has clearly laid out, the Convention of Child Rights has clearly laid out that there are basic rights that the child has. So on the one hand, you have these tests of ability. On the other hand, you have a child's rights for basic, developmental needs, for basic, requirements that would help this child flourish. That are constantly being impaired. So we pick up the ability, we pick up, has this child had a reasonable access to a conducive developmental environment or not? And those are the longitudinal circumstances, yes. So ability, facts of the story, which tells you in what all ways the rights are impacted. We then compound them together in terms of the vulnerabilities that have existed in this child's life. And maybe some of them have resulted in pathways to deviance, pathways to difficulties, which is why the child is now, in the system and presenting to us. So to me, from a mental health perspective, the assessment is supposed to really, elucidate these aspects and not merely abilities, which of their own don't really mean much.
And thank you. Then we have Amar Khajbage. He's a probation officer associated with Dongri Observation Home, where he has been working for the last 10 years. He's also working with children in conflict with law at Special Home. The Dongri Observation Home received the Best Observation Home Award from the Maharashtra government in 2023. His submission of progress reports to sessions and High Court have led to getting bail for children who were staying for long terms in the observation homes. So he has a very important presentation to make. So please.
Thank you. Now, right-based implications of the transfer system. We are discussing on this topic, which is very important. As we know, everyone, that the JJ Act is founded on the principles of the protection, reformation, rehabilitation, and social reintegrations. It recognizes that the CCL are fundamentally different from the adults in terms of mental development, emotional maturity, and the capacity of reforms. Now I will talk about the main important thing, the which rights by base implications have been violating during the process of the transfer system. As a probation officer of Observation Home Mumbai, I am working with the children in conflict with law of Observation Home and Special Home. The JJB does its legal procedures. After PA, the case has been transferred to the Children's Court. But when the order is passed, when order has been passed by the JJB, we work with the children. The child whose current age is 17 years, he was participating in all the activities of the observation home. But after, when he come to know that his case has been transferred to the Children's Court, the complexions, the appearance changes on his face. He goes in a depressed mood. His all activities which he was in participating, his mood totally goes off. And this is the legal procedure. I am not against it, and I don't want to comment on that thing. But in many children's, though they have committed a heinous offenses, I have observed that the remorse on their face, they are repenting on their act, but the procedure is, as he's completed 16 years of age and his case is transferred. In many cases, which children were staying in the long term in our observation home, and I know the progress of that child, and he will definitely do something in his future. So I submitted my progress report to the Children's Court as well as High Court, and that leads the High Court, the Children's Court, to grant the bail of the particular child. And now the children you have seen, which were participating in the drama, 1 or 2 examples were from that. So the main act, the rights of the child is the equality, which is in Article 14. Children similarly place, I will now talk about the which rights are violating of the children while getting their cases transferred to the Children's Court. The rights of equality. Children similarly placed may be treated unequally due to subjective assessment of the mental and physical capacity. Variation in JJB practices across the district. This can be lead arbitrariness violating of Article 14, and the implications of this risk of discriminatory transfer decision. Then Another rights is the life, liberty, and dignity, which is prescribed in Article 21. So here I will talk about the dignity. The children who are admitted in the observation home, the family suffers a lot, and then we send them. If they are in 10th and 12th, so we send them to the examination center, and they will escorted by the police. So the entire school, colleges will come to know that the child is involved in the offenses. So here is the dignity, the this. Uh, then presumptions of innocence. Transfer often occurs before full trial based on only allegations. The child is treated as a potentially culpable at the adult level without conviction. Here the implication is weakness the foundational criminal justice principles of presumptions of innocence. Yes. Okay. Thank you.
So thank you to all of you. So we had good insights, and I think everybody has highlighted the rights of the children which are violated during the transfer system. So we'll just go back to the speakers once again for a short, like 1 or 2 minutes each. First, we'll again start with Anant. Anant, here now falling from Swagata, and also like some things which have been coming up again and again. I would also like to put a specific question to you. In your interaction with children as lawyers, or in the training programs, have you ever come across, or has that question ever been put, whether the JJBs or the lawyers or even the probation officers or any stakeholder who deals with the child, do they ever explain to the child what is the purpose of a preliminary assessment, what does it entail, and what its consequences can be for the child? Have you come across anyone actually doing that exercise of explaining to the children what is going to happen?
Okay. I will have to say very unpleasant things, that the juvenile justice system in practice doesn't like to talk to children. They are brought in.
That, yeah.
I mean, please don't mind if somebody else has done some good practice, but I'm talking broadly. It's very difficult for children to feel heard in these spaces. So as a lawyer, I see people struggling in juvenile boards, children struggling to have basic dignity, police telling, "Seedha khada ho ja, haath bandh le, aise kar le," and being scolded at, shouted at. In this, and that is independent of Section 15. In general, the environment we have not been able to change despite designing the law on a very progressive line. So even in 2000, we had this beautiful structure. It didn't translate. I give you an example of how the practice is turned upside down. When it comes to bail, there is a pressure to file an application for bail. In Juvenile Justice Act, there is no requirement of any bail application. The bail has to be adjudicated on the date of the first production itself, right? But see, the system demands that you file a bail application. Am I audible? Right. In PA, the question which Bharti was asking, in PA is done without state asking for it, So no application is needed from state. In a default setting. So I was very happy when Delhi police recently started filing applications. I said, okay, chalo, at least now they are coming and praying to JJB that you think of doing PA. Children do have very hard time. And I don't know who said, but somebody was saying, I think Swagata herself was saying that children are made to talk, and they trust everybody. They trust the social worker member, they trust the magistrate, they trust the counselor, and then they tell the whole story, and the whole story goes into document. And it's not limited to children in conflict with law. Look what we have done to counseling in child protection system. Counseling as it is practiced in child protection system is an open assault on agency of children. counseling report, child confides in confidentiality and the whole document is before everybody. So it's not limited to children in conflict with law. The trust of children is broken in a child protection system day in and day out on the face of everybody. And many of them are legitimized to my extent. And I
Thank
feel
you.
very unhappy about these practices not being challenged. So I'm glad that you have asked me this question.
Anant, okay, thank you, Anant. So, over to you.
Earlier, the madam told me that what is the procedure you're taken to Kerala to handle the children. We had a very good example of Kaval. You might have heard about that. We are supporting the children by reintegration and restoration to the family and social care. Community-based system we are practicing. Our state coordinator is here. I think he will say a few words about that Kaval project. Okay.
I wanted to also draw attention to arbitrariness, which Amar also spoke about. That I don't think you can do a PA or an evaluation which is non-arbitrary. The examples that we have seen, and there are various tests that Eesha has referred to, Shubham referred to yesterday. My question would be for the mental health practitioners that do any of these tests or evaluations tell us whether a child can withstand trial as an adult? It can tell us about their context, it can tell us about their circumstances, but do your test actually certify that yes, this child has the competency to stand trial as an adult? And I think like Aadhaar, they've clearly told us, please do not use Aadhaar for age determination. Can the mental health professionals tell us what their reports cannot be used for? So you are painting this particular, the entire context for us. This is what the child needs. This is what the circumstances are. Also tell the JJB that, please use my report for these interventions for the child. But can your interventions then be the basis for transfer? Is something that I would like to put out.
No, I don't have a test that can tell whether a child, but I think the question is not can they, the question is should they. I think like what you began with. See, long before the juvenile justice system even enters the picture, rights violation has already affected the child heavily, right? What about the right to nutrition, the right to safety, the right to emotional environmental consistency, education? So by the time the child is apprehended, the system is encountering the cumulative outcome of a sustained rights deprivation. And if a child is coming to you from that context, then what are we even looking at in terms of holding this child accountable for anything that is currently transitioning in their lives? I like to explain this to families using a medical analogy. I say, if you deliver a fracturing blow to a malnourished, fragile leg, will casting the leg really reform and repair the leg? What about the multiple deficiencies that have never been looked at, have been ignored for the longest time? So a compromised development is vulnerable. How can it be culpable? It doesn't make sense. I don't think it makes theoretical sense. See, I think to and again, this may be from a broader framework, but if we are really interested to uphold child's rights within the juvenile justice framework, we're looking at actively preserving childhood development and possibility. If our system fails to do this, we must ask whether we are really protecting society through an act like this, or are we abandoning the future of society, which is the children? I often wonder, sitting in the clinic, why is it so difficult for adults to pay attention to children? Why is it so difficult for us to understand that the origins of any behavioral symptom, any deviance, any problems in their emotional behavioral well-being doesn't arise when the police apprehends them? It arises when parents don't have time to parent. It arises when school don't know what to teach. It arises when the neighborhood, yesterday we were talking about films. I think it has its origins way back in, pretty much the fabric that our society has currently become. So if the future is children, I hope it is. I hope we still believe that we have a future and that future is going to arise from children. Then our willingness to abandon them while claiming to protect society is not just ironic, it is profoundly self-defeating.
Uh, I think a JJ system follows the reformative, not believes in retributive. Means if the child commit an offense, reformative says don't just punish, reform. But retributive said you did wrong, so you must be punished. So in many cases, which are being getting transferred. So we are doing the good practices in our observation home. So I firstly clear that the way the children's case has been transferred to the sessions court, then they depress. We have noticed the very in cases self-harm, unwillingness of participating any conductivity. So we started to keep them engaged a circle program along with Ashiana, Chai Pe Charcha, and also we in circle we sit all together, and the purpose of the circle is to make the comfort to the child, so that he can participate in the activities, he can manage with the other children as a routine, and our board members also participate in that circle. So the good practices is conducted, and our focus and our intention is to make the comfortable child during his stay in the observation home. And as I say, the preliminary reports which is received to the JJ board in Mumbai also, it is only mentioned that the child is mental and physically capable of doing such commit and such offences. Some magistrate, our prior magistrate also asked the team of the JJ hospitals, Department of Psychiatry, which procedural, which methods they use to calculate their evaluations and put their remarks. So then also directed to the concerned doctor to put the methods which have been used, so that we can mention in our order the particular order to send to complete the PA and transfer the case to the jury. Thank you.
So thank you. We'll take a few questions. I think all of us do know each other by now, but still I would just say for the purpose of recording, if you just introduce yourself, and we'll first take the questions and the answers can be later. You can put your comments, or if you have a question to a specific speaker, please name the speaker. So yeah, we'll start from this side. Yeah.
It occurred to me again when Swagata was speaking. I'm Aarti. I'm now a professor at the National Law School. I used to be a lawyer, a practicing lawyer. I was just thinking, have we ever come across a case where a child has refused to go for a preliminary assessment? Because I was thinking it in terms of the protection. It occurred to me then, this could be completely not tenable in the law, but I was thinking of it as in the protection of, in Article 20, sub 3 of the right against self-incrimination. Why should I be compelled to make a testimonial statement which could potentially incriminate me? And do I have the right to say no? I mean, there is some work on this in the context, in a very old case in Katikalu, Ogad, and so on, and more recently in your right against narco analysis, against BEAP mapping, against those kinds of involuntary tests. What is voluntary about this? So can a child say, I will not participate in the preliminary assessment, do what you like?
Okay.
And what would be the what would be the legal result of something on those lines? I don't think it's ever happened, but I'm just thinking,
Yeah, please.
if I could.
Oh, I will come back to you. Please. Please introduce yourself.
I'm Video from Goa. Okay, I'm 17 years old. I've committed a heinous crime of murder. I've been apprehended, put in observation home. You meet me after 2.5 months of me staying in observation home. In this period, I meet a lot of other children in conflict with law. My parents have appointed a private lawyer for my case. My lawyer has briefed me what to tell you and what not to tell you. I come before you and I say, I did this because I was sexually abused, and this is my retaliation. You know, just a scenario. Because most of these cases, ma'am, by the time it comes to the experts, they are already briefed at the grassroots level, not only by their lawyer, but within the institution themselves. You will have caretakers or matrons or the CCLs have already been there in the institution for a very long time. Ma'am, if that's the scenario, I have committed a crime in the month of October. Now I have been spoken and I've been told how to present myself to you, and I present myself as a victim to you. Ma'am, would you give me an assessment of what I was in the month of October? You know, that's just a
Okay.
scenario.
So, yeah.
Sort of to add on to what I think Swagata was saying and what Aarti was saying, what Swagata said, that these tests, are they really meant to determine competency for trial? I would actually go a little bit further, because these tests, from what Dr. Shubham was also saying yesterday, like you're looking at the story of the child and different kinds of ability, etc. Are these tests designed to make a determination on whether someone can be incarcerated, sent to jail for 10 years? Because that is a very, very strong possibility of ultimately happening. That is what the test is going to be used for, not for therapeutic purposes, not to design a rehabilitative plan. Is that sort of kept in mind, that it is a decision between liberty and incarceration for many, many years in an adult prison?
Yeah.
Hi, I am Pupul Dutt Prasad. I am a professor of practice at a college in Greater Noida. I just have a brief observation to make in response to what Dr. Sharma said. She said how these children are not a typical demographic for serious offending. I completely understand the spirit in which you say, and I also don't think that you say it on the basis of the crime data. The crime data does not reflect. I don't think any one of us seriously take that children commit only 1% of the total crimes committed by in India. So because the average figure in a comparative figure is much higher, 20 to 25%. So if 20 to 25% of total crimes are committed by children, then would we consider children as not a typical demographic of offending? That is first point. The second point is about the danger that lurks here of taking offending behavior as something that is exceptional rather than normal. And that can lay the ground for, discrimination being made between children who are good and bad. So I understand the rationale behind saying this, but we should also be, cognizant of the fact that offending behavior can be normal. It is normal. It is very often the case of who, are caught and who are sort of scooped into the criminal justice system out of so many people who commit crimes. And so this can be can lead to unintentional and counterproductive results. It also depends on how serious offending is constructed. So what if we take certain offenses to be very serious when in fact they ought not to be even criminalized? For example, cases under POCSO.
Pupul, can we just go to the next person?
Yeah.
Please keep your comments or questions a little brief so that others get the opportunity. Yeah, please.
My name is Kumar. I'm a teacher and researcher of criminal law and juvenile justice. I'm from Lucknow. Since yesterday, we have been talking about how arbitrary discriminatory and, of course, violative of many other fundamental rights. This entire PAs, there can't be any doubt about it. And very rightly also raised this issue that how it goes against that protection that the Constitution provides against testimonial compulsion. A child is alleged to be in conflict with law, and there are so many presumptions against the child that set in, and we subject the child to PA. My question is that, because though it is unusual to ask a question to the moderator, but my question is directed to you, ma'am, and also Swagata, that when section 15 says that it's not trial, what transpired during deliberations, that we have Rule 10 capital A, which reads that while making PA, child shall be presumed to be innocent unless proven guilty. Now, guilt or innocence can only be determined during the full-fledged trial. That's a different stage altogether. Don't you think that this Rule 10A, which was part of the original and still part despite the 2021 amendments, is also responsible for adding to confusion as far as the whole idea of PA is concerned?
Okay. Another couple of questions. Yeah. So
Ma'am, this is my question, ma'am.
Okay. We'll just give to.
Hello.
Okay. So we'll take 3 questions. Yeah. Please keep them brief.
Yeah. First of all, I'd like to make a comment that, we keep talking about children in conflict with law as a demographic. I think a few of us in this room could have been considered as children in conflict with law when we were that age. Yes. I, for one, for sure. And the second thing I would like to say is what Swagata, to carry on what Swagata said. When we talk to children and saying that we are there to help you, we are actually betraying children. We are falsifying the way we present to them to get information to help the system and the act, which is completely against what, as Dr. Sharma says, is what are we talking about when we're talking about children? And Aarti, to just respond to you, what option do children have to say no preliminary assessment? You say you don't want breakfast, you're whacked. So, yeah, we have to try. That's a different story. The other point I want to say is, the circumstances, yesterday in this whole mental health panel, there was a whole lot of things about skill deficit and, talk about the circumstances. My point is, even at this age, I will say I have a skill deficit. There are circumstances which make me do things. Do you think that just a couple of sittings actually bring out the flavor as to what drove me to do what I did? And is it what drove me to what I did, the point, or the context from which I came from, which drove me to this point? I think this whole mental health assessment in terms of preliminary assessment, the people who are doing the preliminary assessments in terms of the mental health professionals, I am no offense meant to you, I think really need to understand the other side of the story too as well.
Okay. Please give to Justice Lokur.
Unless we make questions, normal questions to the children, we can't.
Who's speaking?
Yeah, this is me.
Okay.
Unless we make normal questions to the children, we can't gain the trust of the child, first of all. When we are doing in that process, the child may disclose everything. But putting in paper and not putting in paper is one thing we have to look in. And preliminary assessment report is not a trial again. So that need not to be taken into consideration at all. And one more thing, we are still, after 10 years also talking about a child who is apparently a normal, unless vulnerable conditions, he came to the JJ system. But what about the children who are MR children now appearing in the JJ system? We have not yet formed any procedure for the children, proper children's now. And MR children are turning up in the POXO cases. Anything to be done for the MR children, ma'am? What's the procedure and how these children will be safeguarded from the for the safe trial?
Okay, thank you.
No, I just wanted to know, by way of information really, is there any procedure that is established or followed in a preliminary assessment? And if so, can you just give a rough idea?
Okay, just one last
One
question.
last
We'll take
question.
from the back and then we'll come to her.
Hi, I'm Shruti. I'm faculty at National Judicial Academy. I just had a question. We are talking about a system that we operate, which is entirely welfareistic. And now we have a change in the procedure, which brings in a slightly stricter method, which talks about accountability. In that perspective, I have a question for Anant sir. We are talking about a child who's going through a procedure. Are we doing enough to talk about the due process rights, the fair trial rights, and natural justice rights of the child? Specifically talking about hearing, evidentiary rights, defense rights of the child in this procedure, considering the implications of Section 15 and Section 20 are life-altering for that particular child in question.
Okay, so last Enakshi and then we come to Dr. Eesha. Yeah. Half a minute.
Yeah, less than half a minute. What is clear from the conversations yesterday and today, and of course we knew it, it's just that the conversations reiterated and reinforced the fact that the entire process of PA is a violation of both constitutional rights and absolute basic rights to justice. But given that, now we have two options, right? Either we try to change the law and create enough evidence to do that. But till we do that, there must be something else that we have to do to ensure that the process is a little bit more just. So I was just wondering if there is any thinking around, I mean, otherwise we are going to end the day in like another 3 hours. But there has to be something that we think it's quite clear. We're just sort of in a sound box, in an echo chamber, reiterating how badly we feel about this. And how unworkable it is.
Thank you. So Dr. Eesha. So quick
Geetanjali
response.
ji. Okay.
No,
May
I think
may I just have
no,
one
sorry.
question?
Now we'll just have to go to Dr. Eesha. So 50 minutes.
Thank
Because
you.
most of the questions
for
are
the
directed to
questions.
her.
Yeah, I'll try and cover most of them. So to respond to your question first, so the procedure that we're following is that once the child comes to us, and usually they come from the observation home, we look at whatever documentation is there of all kinds from the observation home, the superintendent, or if there's an FIR copy or the SIR, whatever. So we look at the documentation. The next step is we insist that the child must be present with the immediate caregivers. So in most cases, we avoid interviewing or doing any kind of an assessment on the child alone. There are rare instances where we are pushed to do this, where the police are just not able to get the family to come, but that's not a standard protocol. Now, as a first step, what we do is what we do in any psychiatry OPD is that we assess the developmental achievements of the child, and we assess whether there are any active mental illnesses. So that is something that is common to any psychiatric assessment. And like I was saying, that is the one small part of the assessment where we look at abilities and absence of illness. After that is, in a way, we actually try to answer the story that who is this child, where's this child coming from, what have been this child's developmental family, schooling. So as 360-degree an assessment of this child's life as possible to the current point, until they got apprehended by the police and came to the OH and include. So the idea is to basically get this child's story, and we do that by looking at different components of the history as the child and the family are narrating those to us. Any child mental health assessment rather is incomplete unless you have spoken to all significant caregivers in the child's environment. So to the extent possible, if there is a school that can give us a report, we get that. If there are other significant family members, we ask them to come in. There have been few instances, which is unfortunate because ideally it should be many such instances, where the social work from our department have actually gone and visited the child's home to get a sense of what is it, really that the child's life is looking like. So now, whatever I'm saying is documented in a pro forma, which actually, has these headings and subheadings. And I think what I tell the students is that even if you just have an answer to every heading, by answer we mean whatever is the best information available, it really adds up to a whole lot of information about the child. So that's what we are following right now.
Thank you. So Anant will come to you.
Geetanjali ji, this is a very important
No,
thing that I have
please,
to ask
we
Eesha
don't
ji.
have time. I mean, I've already got the message that you have to wind up soon. So
Okay,
Anand,
didn't
quickly,
she
1 minute
ask?
response from you.
I don't know which question to respond. Shruti has asked me one question
Yeah.
on evidence. I think what I will say is that the word trial, that the PA is not a trial. I think it means that please don't look at the document of persecution, because that's what we do in trial. At the stage of PA, when the law says it's not a trial, it actually means that please don't look at the documents given by police, because they will only present the side of the victim. What is the complaint? Now, this is not practiced. Now, trial, the section is read in a completely different manner, but this is what I think is the meaning why PA is not a trial, right? And I have a whole theory around it. As far as the evidence is concerned, at the stage of PA, children are totally defenseless, as a matter of fact, right? And that's why the child who's facing PA is much more vulnerable than an adult accused in a criminal court. Every stage that accused has a right to be heard, to be represented by a counsel. The child who's facing PA, forget about the applicability of law of evidence and any other fair trial process, completely arbitrary. I don't want to repeat it, but what I want to say is that a lot of work is being done to counter these malpractices and the misinterpretation of law. In a state of Chhattisgarh, let me just conclude by saying this. In the state of Chhattisgarh, Chhattisgarh High Court gave a judgment completely writing off the JJ Act, saying even if the state wants to reform a child, the state will not be allowed to reform because it will lead to multiple cases like this. Now, Maharuk took that case to Supreme Court, and the judgment was so bad that the Supreme Court, on the date of issuing the notice, said that this judgment is not going to be used as a precedent. That terrible that judgment was. So while we are discussing and debating, a lot of work is also happening to prevent the damage which is coming on children through this.
Okay. So Swagata, you have half a minute. Okay.
Yes. So, Aarti, it's been done. Children have lawyered up, and that's gone against them. So we've spoken to JJB members who said, when the child does not participate, it shows how manipulative the child is, and therefore we will transfer. So you see, lawyer up and face consequences. Asking of questions, I totally get building rapport with the child. It still does not take away the fact that you are taking information. You may not put it in paper, and I think that's very dangerous. When we say that we will not bring it into our record, but it's imprinted in our mind. You are using that information, but you have not, articulated that I am using that information. And for Inakshi, I think there are a lot of harm mitigation strategies that everybody has already spoken about. And to begin with, I think we need data. I think yesterday's session established that. So data is one starting point. Second, of course, in terms of Tamil Nadu, at least in terms of romantic cases, please make sure that they're not transferred. They are getting transferred. So, we think Tamil Nadu is not doing it, but there are other states that do transfer in romantic cases. Legal representation, so the principle of participation and natural justice, that is something we can ensure. But harm mitigation cannot mean that let's train everybody to say, hey, let's do this better now. And,
Okay.
Yeah.
Okay, so thank you to all the speakers. I'll take 2 minutes being the moderator, and since a question was also addressed to me. So in fact, as I mentioned earlier, I was part of the drafting committee. So we had deliberately introduced that provision in 10A because we were so worried about, this whole PA going against the principle of presumption of innocence of the child. So we just wanted to reiterate that. So that is why it was put there. It's not meant to create confusion, but it is just to remind everybody again and again that we have to have the presumption of innocence, irrespective of the fact that Section 15 requires us to work in a particular manner. So from all that I have gathered and what we have been discussing, I just have a few points to make. So I would again stress on capacity building, sensitization and all. As Arul did mention yesterday, Anant does have a slightly different picture about the JJBs in Delhi. But as Arul mentioned, we have very few cases of PA going to the children's courts in Delhi. So I think it needs more capacity building, sensitization for JJB members, for the JJB principal magistrates. We also need to have sensitization for mental health experts, not in the sense of how they are to carry out the assessments and all, but more about what they are supposed to look at. I mean, it's not, we assume that they're mental health professionals, so they know what they have to do, but they also need to know the context, because they're not legal persons, that they're doing PA in a particular context. And so for the purpose of PA, what they're supposed to look at. So I think that sensitization or training needs to be there. The other stakeholders, especially lawyers and other stakeholders who are dealing with the children, probation officers and all, they also need to be sensitized about informing the child. And I know that, the child really cannot say no, as Aarti was saying, and the children have to face the PA, but we have to at least inform the child about the process that the child will be going through. So there also the question of SIR becomes important. It is very important that the SIR and the ICP are framed. ICP obviously comes at a later stage, but SIR becomes a very important document. So it's just not a tick mark document. We work on the SIR, so a proper document is there before the JJBs. In the end, I will again say, so what Swagata has said, we all are talking about violation of rights of children, but then somebody has to go and file a specific case challenging Section 15. Till that happens, we cannot, close our eyes and say that it violates the rights. So we will not try to minimize the effects of the system. We have to, as Inakshi also mentioned, we do have to work on how at least we can try to ensure that, lesser and lesser number of children do go to the children's courts. And again, when the children do go to the children's courts, I mean, if some of them do go there, again, there also we have to work and try to work with the children's courts to ensure that, the principles or the objectives of the JJ system are followed there. Section 12 is looked into, Section 20, Section 12, all those sections are looked into even at that level. So thank you so much for giving this opportunity to us. Thank you so much.
I would like to warmly thank Ms. Goel for graciously moderating this session and our panelists for sharing the time and insight. Please accept the small token of our appreciation as a heartfelt thank you. And please wait for a group photo. I have to sit this now. Okay. Okay.